This is Dalle-2, focusing on the newest developments in AI and the legal space. Please subscribe to my channel. Generative AI has been getting significant attention in recent months with the demonstration of ChatGPT that has seen considerable interest from the overall population. However, new litigation against generative AI firms has sparked an existential crisis among creatives and copyright laws about the contents of training data. Platforms such as Midjourney, Dalle-2 and Stable Diffusion provide AI-generated images based on natural language description and have acquired a considerable customer base in recent years. Real artists aren't pleased by the possibility that generative platforms like Midjourney, Dalle-2 and Stable Diffusion could lead to the debasement of their craft. Others, meanwhile, believe that these models are spitting out little more than cheap reformulation of existing copyrighted work. Three artists mounted a civil lawsuit in San Francisco and London against Midjourney and Stable AI on the grounds that the models used the works in training databases without permission and that consequently any works produced were derivative. Stock photography service Getty, meanwhile, has sent a letter to both warning of future legal action after several generations appeared containing ghostly reproduction of the platform's famous watermark. Two main arguments are at play in the lawsuit against Midjourney and Stable AI, namely that the firms infringed the copyright of the artist by using the images without permission, and that the inclusion of these images in the training data makes the outputs effectively derivative content. The argument about training data is perfectly reasonable. Most jurisdictions do not allow anyone to use copyrighted data unless you have a license, but the challenge is to get one such license. The exception to these rules. In the US, for example, there's a broad fair use doctrine, which permits the use of copyrighted materials for the purposes of free expression or for a transformative purpose. There's much less leeway in European jurisdictions, however, with countries such as Germany and the UK only permitting specific scenarios where it's permissible to use copyrighted materials. That would excuse quoting copyrighted work or painting a portrait in a similar style to another, but not necessarily hoovering up artistic images to train an AI model without permission of the rights holders. For example, for Stability AI to be able to argue a broader fair dealing defense in the UK is probably going to be more difficult than in the United States because they are not necessarily falling within any of the fair dealing exceptions specifically set out in the legislation. It's also odd to some lawyers that generative AI firms are being sued and not those to compile the dataset. In the case of Midjourney, that would be the large-scale artificial intelligence open network, Lion, based in Germany. If Lion created a dataset, then the alleged infringement occurred at that point, not once the dataset was used to train the model. It is important to note that Lion doesn't actually keep copyrighted images on file, but only links to the original locations on the internet, which is perfectly acceptable under European and German law. Any arguments that works produced by generative AI are in some way reproductions of original works is also hard to prove. After all, it is broken down into mathematical abstractions, which are then used by the model to help chart the commonalities between the aspects of a given photo, painting, or rendering and written text prompts. One might compare the process to an artist committing all the pictures in Word to memory to learn how to create something new, rather than incorporating fractional chunks of each image into the latest creations. Not every artist balks at this process. Artists have used AI to create images for the better part of a decade and wouldn't especially mind if its works appear in a generative AI dataset. Indeed, the worry is that a victory for the artists in the Stability AI suit would stick a philosophical wrench in the development of new generative services. Hence, if there's a precedent that learning from material is something you have to ask for permission, then the question is, why does this only apply to machines and not humans? For Getty, they may be on a stronger legal ground with its suit. It is suspected that the firm will argue that the inclusion of the images in AI training datasets is simply a violation of its website terms of service, an oversight that could be remedied in future with simple licensing agreement between the firm and generative AI services like Midjourney. But even then, there may be the issue that the justification is that robots have the capacity to enter into a contract. Until verdicts are reached in these suits, generative AI firms are exposing themselves to significant legal risks across multiple jurisdictions. One might imagine the exposure being limited by not running the service in a country where the risk is more pronounced, excluding works by persons of that nationality. But such limitations are technically very challenging to achieve. Regulators seem to have been caught by surprise by the legal ramification of generative AI. In the UK, for example, a sweeping consultation by the Intellectual Property Office on how copyright law should be amended to foster innovation in AI ended just before the emergence of ChatGPT. What it seemed poised to recommend allowing less discriminate data mining for commercial purposes, intense lobbying from the creative industry seems to have halted that move for now. One solution to complaints of copyright infringements in AI text and data mining may be the creation of automated filters, some of which have already emerged. GitHub, for example, rolled out a filter in 2021 that prevented Copilot from suggesting anything that was identical or substantially similar to its publicly available code. Though this didn't stop another lawsuit targeting Microsoft, GitHub, and OpenAI for facilitating copyright infringements being filed. Stability AI too has promised to include an opt-out provision for artists in its next iteration of Stable Diffusion. Such workarounds are set to become more common as jurisdictions compete with each other to allow generative AI to chin up productivity in their respective economies. What that could mean for the future of copyright laws is hard to say. History shows, however, that its governing principles can resist the mild panic that accompanies the introduction of new technology. Book printing was the first time where you needed a copyright law followed by photography become the next great controversy for lawyers to solve. Over time, though, a new consensus emerged over where and when it was further to use protected materials that accommodate the widespread use of the technology. A process is just as likely to happen again. In the meantime, though, we may see a slowdown in new generative AI application while these lawsuits play out. Developers are reluctant to commercialize the services for fear of courting litigation from record labels. Google is one. The search giant has proven reluctant to make its musical AI model open source, partly because its developers discovered that 1% of its outputs were direct replications of the songs from its training data. It is unlikely, however, that the current wave of AI lawsuits will see releases grind to a halt. Now that the general principles of building such generative application from large foundation models have been firmly established, the future of the field is no longer contingent on the existence of players such as Midjourney, Stability AI, or even OpenAI. They could get sued out of existence and artificial intelligence would continue happening as is it right now. This is Dalle-2 AI, focusing on the newest developments in AI and the legal space. Please subscribe to my channel and put any question or feedback in the comment section. Goodbye.